Go ahead.
Good afternoon, Your Honor. My name is Colin Spangler.
My name is Enoch.
And together we represent the state of Carolinas in this case.
Okay.
Before we proceed, we have a few housekeeping and substantive motions that we'd like to present before the court.
All right, go ahead.
First, we'd like to confirm that this is a standing jurisdiction.
It is, yes.
We'd also request that all evidentiary arguments and objections be heard in a constructive sidebar outside the presence of the jury.
Okay, they will be.
We'd also ask that pursuant to Rule 615, that all witnesses be constructively sequestered. In this case, the only witnesses that Rule 615 applies to are one defense witness, Mr. Robert Saunders.
Okay. He will be sequestered. Any objection to that?
No, Your Honor.
Okay, without objection, he will be sequestered until such time as he is called to testify.
Your Honor, we'd also ask the court's preference on where to tender evidence after it has been properly admitted.
Place it up on this side bench up here.
Yes, Your Honor. We'd also ask the court's preference on approaching opposing counsel, witnesses, and the bench.
Ask each time.
Yes, Your Honor. And finally, we'd ask that all witnesses be constructively presumed to be sworn.
They will be.
All right. And with that, other than the substantive motion, my co-counsel would like to present the defense. The prosecution is ready to proceed.
Does the defense have any other housekeeping matters to attend to?
Yes, sir. My name is Elizabeth Smith, and this is my co-counsel.
I'm Clair Hollingsworth.
Okay.
And we represent Josh Wallace.
Okay.
We asked freedom to move about the well, which I don't think I did.
I think that's been covered, but yes, you have permission to move freely about the courtroom.
We also have a pre-trial motion, which we would like, motion to eliminate.
Okay, we'll start with the state on that, since any other housekeeping from the defense?
No, Your Honor.
Okay, go ahead with your motion, state.
Your Honor, the state has charged Joshua Wallace, the defendant, with the murder of Tamara Eigenbrot and arson, and we would like to present this motion in limine to restrict any mention of a person named Chad. We believe that the defense may mention him in an attempt to offer a third-party guilt claim. However, the only supplied notice here today was that of an alibi, and no actual witness will actually link Chad to the incident beyond an allegation that Chad owed some child support and might have been abusive in the past. That defense will only offer this evidence to mislead the jury, and it's improper under 403.
Okay, anything from the defense on that?
Yes, Your Honor. We're not using Chad. We're not using any evidence or presenting evidence to say that this was Chad that did it. However, we are using this evidence to show that the prosecution, as well as their witness, Detective Dillinger, should have and could have done a better investigation. We're not using testimony of Chad to prove that Chad did it to the extent that we're using it to show that there was other avenues that should have been explored and that the prosecution did not do so.
All right, if that's the only, if that's the only thing you offer, in other words, there's no allegation that Chad was actually involved in the crime, that'll be permitted. Anything beyond mere questions about what they did and didn't do investigation-wise is going to be sustained if the state objects to that, all right? In other words, you can ask questions about who they did and didn't investigate, but specific, accusations against people without the substantive evidence is going to be
Yes, Your
decided.
Honor.
Okay.
Absolutely.
So that motion is granted technically, and we'll move from there.
Thank you, Your Honor. At this time, the state is ready to proceed.
Anything else from the defense?
Yes, Your Honor. We had an exhibit 16, that has been labeled as the burned body of Tamara Eigenbrot. I'm showing opposing counsel. May I approach, Your Honor?
Yes.
This is the exhibit. The rules state under Rule 403 that this is more prejudicial than it is probative.
Okay.
We believe that this evidence will color the jury in their favor, and it will be unfairly prejudice the jury.
Okay, anything from the state on that?
Yes, Your Honor, just to clarify the reading of 403 the defense counsel just gave you, it's not that the piece of evidence must just be more prejudicial than probative. You must determine that this piece of evidence is substantially more prejudicial than it is probative. In this case, we're dealing with an arson, a case that involves a home that was completely destroyed. By the very nature of this case, the jury members aren't going to get to look inside of that home or travel to the crime scene. This photograph that we have is the only picture of the inside of that home. Today, it's the prosecution's intent to use this photograph to illustrate and corroborate testimony that is going to show the damage to the inside of the home, the severe damage specifically to this bedroom where the decedent, Miss Tammy Eigenbrot, was found. And we're not using this picture to illustrate any injuries that Tammy Eigenbrot suffered. And in that case, the probative value of this photograph, just to corroborate the damage to the inside of the home and clue the jury in as to what actually took place in that home as it was burning, that probative value is not outweighed by any substantial prejudicial effect.
If I may be heard.
Yes.
The state already has a picture of the house which can show the jury what was going on in the house and around the house at that time. Any evidence or the admission of this evidence right here would not just the prejudicial wouldn't just outweigh the probative value, it would vastly outweigh the probative value. This is a very, very graphic image of a young girl burned to death. This will most certainly color the jury in favor of the state's case. This is, at this point, after we have stipulated that Tamara Eigenbrot died in this fire, what she died of, that she died from the fire. At this point, any other evidence would be cumulative evidence and would be unfairly prejudicial.
Anything else?
Yes, Your Honor, I would just reiterate that this is the one piece of evidence that we have that clues into what the inside of that home looked like after the fire took place and caused the death of Tammy Eigenbrot. It is not the state's intent to use this photograph to prove any injuries or actually what happened to Tammy. All we're using this photograph to do is to show that her room caught on fire, suffered extreme damage that is shown in this photograph. And further, I'd ask the court to look closely at the photograph, and based on the state's viewing of this photograph, there's no body that can be seen. All we're looking at is a bed, a burned dresser, and the debris from a fire. Therefore, there's no prejudicial effect in this, and the probative value is not outweighed by any prejudice that the court may find.
I'm going to overrule that motion. Certainly that photo can come in, but if they start getting into multiple cumulative photos of the body or that are graphic, et cetera, then we'll address that. But if this is the only one they're going to enter, then it's probably going to be allowed. So I'm going to overrule that at this time. Anything else?
Yes, Your Honor. The arrest record, we've received no notice if the counsel is or is not, if opposing counsel is or is not going to use a prior arrest record of our client, Josh Ross. However, if they plan to use these, this would be the prosecution using this to make a propensity argument, as well as against the rule of evidence 404B as well as 609. These state that PAC's actions cannot be admitted to prove conformity. These prior bad acts have nothing to do with today's case, and thus they're irrelevant as well.
Do you all plan to offer
Your Honor,
the
at this time
defendant's
we
prior
don't-
criminal history?
Your Honor, at this time we don't plan to go into that unless the door is open.
Well, that'll be granted then, and obviously if the door is open to prior bad acts, then we'll address that outside the presence of the jury at the time. Anything else?
No, Your Honor.
Okay, then state, you may proceed with your opening argument.
May it please the court.
Yes.
Ladies and gentlemen of the jury, opportunity is the friend of desperation. Today, you're going to hear about a man's desperation for his ex-girlfriend, Megan Eigenbrod. You're going to hear about his opportunities to make her pay for what he thought she did wrong to him. Today, you're going to hear about the defendant's decision to commit his crimes because of what he thought Megan had done to her. Those crimes were murder and arson. On July 20th, 2014, the defendant, Joshua Wallace, was behind Megan Eigenbrod's house and took a Molotov cocktail, a firebomb, and threw it at her house. Threw it through the window, and threw another, and another, and another. Joshua Wallace did this because he had the opportunity, he had the desperation, and he wanted to get back at Megan. Ladies and gentlemen of the jury, my name is Enoch. And along with my co-counsel, Colin Spangler, we represent the state. Today, we're going to show you through the evidence and testimony presented right here that the defendant committed the act of arson and through that killed Tamara Eigenbrod. And that night, Tamara, Tammy, lost her life because of the defendant's actions. Now, why did the defendant do this? You're going to hear a lot about Megan. You're going to hear about Tammy. You're going to hear about the defendant and how he just wanted to get back at his ex-girlfriend. You're going to hear how 3 weeks before this crime took place, 3 weeks before this arson, Megan broke up with the defendant. Yes, Megan used to date the defendant. Megan opened her life to the defendant. He lived next door. She opened Tammy's life. She even let the defendant move in with her for a time. But 3 weeks before this crime, Megan had had enough. Megan broke up with the defendant, asked him to move out. She moved on with her life. She rearranged her house. She even started seeing other people. She had started to move on. That was until July 19th. That's when the defendant showed Megan and showed Tammy that he hadn't moved on, that he was angry. He was angry. He called, he texted, left voicemails numerous times on that day. Kept calling, kept calling, kept calling. What happened when Megan rejected him one more time? The defendant asked her to leave some stuff that he left out on the front porch. It was just another opportunity that he had to try to get into her life. Megan did. When the defendant arrived, he tried to get her to come out to the front porch, and she wouldn't. All those voicemails, all that anger. You'll hear the defendant took his stuff and left. But that wasn't the only time he was there that day. Ladies and gentlemen, you're going to hear about the defendant's opportunities. 3 in particular. First opportunity was a trail that led from behind the defendant's old house, right next door, all through the woods. You're going to hear how the defendant tried to use this trail to conceal his movements. You're also going to hear how this plan of his failed. Detective Dillinger, the lead detective in this case, found the defendant just outside that trail less than an hour after this arson occurred. Just an hour after this. The defendant, you'll hear this from Detective Dillinger, was covered in mud. He had a red backpack with him, and inside that red backpack was a lighter, a flashlight, an empty steel reserve beer can, And you'll hear, additionally, from Detective Dillinger, the defendant smelled of gasoline. Second opportunity. Second opportunity was the defendant had all of the supplies to commit this crime. You're going to hear how Detective Dillinger went down that trail, found Coke bottles littered on the ground. You're also going to hear how he found empty Steel Reserve beer cans. What did the defendant use these empty Coke bottles for? He used them to make the Molotov cocktails that he threw at Megan's house. He used those Molotov cocktails. Now, for all of us that don't know what Molotov cocktails are, you take a glass bottle, you fill it with a cellar, like gasoline. Then you stick a wick into it. You can use a piece of a shirt. Then you light that wick. And the person that is making this Molotov cocktail will then throw it at their intended target. Now, you already heard about the glass Coke bottles. What about the cellar? Detective Dillinger learned that the defendant lived next door. So he searched in the crawl space. What did he find? An empty gasoline can. An empty gasoline can. The third opportunity. The defendant used to live with Megan. And you'll hear how he targeted the room that Megan used to live in. Now the defendant didn't know Megan had rearranged the house, but that room was targeted. And on that night, Tammy was the one that lost her life because of the defendant's actions. Desperation. Desperation and opportunities. You're going to hear about that today. And then my co-counsel, Colin, will return at the end and speak to you one more time. We're going to ask you, ladies and gentlemen of the jury, to return a verdict of guilty to the defendant for arson, first-degree murder of Tamara Eigenbrot. Thank you.
Defense?
May it please the court?
Yes.
Wouldn't it be great to be able to be in two places at the same time? Think of all the things you could do and all the places you could go. You could be here in this jury box right now, and also at home taking a nap or mowing your grass. But unfortunately, we cannot be in two places at the same time. It just isn't possible. And that, members of the jury, is what today's case is about. The state is going to ask you to believe that Mr. Wallace was in one place, when all of the evidence and eyewitness testimony puts him in another. As you just heard, the state has accused Josh of burning down Miss Eigenbrot's home. But the evidence, the eyewitness, and expert testimony we present to you today will show that he was more than 1.5 miles away at Three Monkeys Bar and Grill at 2 a.m. when the fire started. And as we know, members of the jury, Mr. Wallace could not have been able to be in two places at the same time. Good evening, members of the jury. I'm Clair, and I, along with my co-counsel, Liz Smith, represent Josh Wallace. Now, Josh is a hard-working man. He lives an honest life. He has a German shepherd named Sam, and he works as a landscaper. But Josh wasn't content to just be a landscaper for the rest of his life. He wanted a new job where he could be successful. So on July 19th, he walked to the Bass Pro Shop in Concord, where his acquaintance, Robert Saunders, worked. Now, to illustrate how hard a worker Josh Wallace truly is, he doesn't have a car, but he has places like the Bass Pro Shop that he needed to get to, so he would walk. Now, as he arrived at Bass Pro Shop, he asked Mr. Saunders if he could get a job there. But Mr. Saunders was really busy at the time and decided to set up a later meeting that night where they could do a mock interview, fill out some paperwork, and talk about the job. After this, Josh walked to his old girlfriend, Megan Eigenbrot's home, and played with his dog for a while, and also got some documents he'd need to fill out that paperwork later. Then he left and walked to the Three Monkeys Bar and Grill, where he met with Mr. Robert Saunders. And they did that mock interview. They filled out that paperwork. They talked about the different opportunities for Josh. and they started talking about life. They found out they both had golden retrievers, and they ended up talking over drinks until the bar closed around 2 a.m. Then Mr. Saunders left, and Josh left to walk home. About 45 minutes into Josh's walk home, he was interrupted by Detective Dillinger, who investigated Megan Eigenbrot's fire. Now, Josh cooperated with Detective Dillinger because when he found out what had happened to Megan Eigenbrot, he wanted to do everything in his power to help the police catch the person responsible. Now, unfortunately, Josh is here today, wrongfully accused. And we intend to show you today that because of the detectives' lack of investigation and shoddy police work, the prosecution has come to simply the wrong conclusion. The prosecution has come to a conclusion where Josh Wallace would have to be capable of being in 2 places at the same time. The prosecution has charged Josh with arson and first-degree murder. The judge will explain this law to you in detail when we're done here, and you'll learn that this means the prosecution must prove that Josh was there and that he intentionally started the fire that night that led to the death of Tamara Eigenbrot. The prosecution must prove all of this to you beyond a reasonable doubt. Beyond a reasonable doubt is the highest burden in our judicial system. And it means that there can be no other reasonable alternative for what may have happened. And if after looking at all of the evidence, there is even one reasonable doubt, then Josh Wallace is not guilty. Now keep in mind that we the defense have no burden. We don't have to call a single witness or enter a single piece of evidence. That is because there's presumption of innocence, of Josh's innocence. And we don't have to provide you with a reasonable alternative, but today we will. After the state has rested their case, we will call 2 witnesses, Mr. Robert Saunders and Professor Michael Pennington. Mr. Saunders will come and he'll tell you that he spent most of July 19th with Josh Wallace. He'll tell you that they did the mock interview, they worked on paperwork, they talked about life over drinks, and that he and Josh stayed at Three Monkeys Bar and Grill until it closed, around 2 a.m., and that they both left and Josh walked home. The second witness we'll provide is Professor Michael Pennington, who has extensive experience in the field of forensic cellular analysis, and he'll come up here and tell you how cellular analysis works and what exactly cell data proves. Now, he examined the cell data from Josh Wallace's phone from July 19th and July 20th of 2014, and he'll show you today that Josh Wallace was not near Miss Eigenbrot's home at the time of the fire. In fact, he was 1.5 miles away from her home around 2 a.m. when the fire was started. The state has told you they plan to call Miss Eigenbrot as well as Detective Dillinger. When they give you their testimony, we want you to listen and ask yourself some questions. We want you to consider if any witness they call saw Josh near Miss Eigenbrot's home around 2 a.m. on July 19th. We also want you to consider, did the police find any physical evidence, DNA or fingerprints that links Josh to the scene? And finally, did the police do any investigative work as to where Josh was on July 19th and July 20th? We anticipate that the answer to all of these questions will be no. We expect that the prosecution will not provide any eyewitness testimony that Josh was at Miss Eigenbrot's home when the fire started. In fact, the state isn't going to provide any evidence or testimony that contradicts Mr. Saunders, who says that he was with Josh until 2 a.m. when the fire started. We anticipate the prosecution will not be able to provide a single shred of physical evidence, even though Detective Dillinger sent off numerous samples to be tested. Not one of those samples came back positive for Josh's DNA or fingerprints. Finally, you will hear that the police failed to interview any of the bartenders or patrons that were at Three Monkeys Bar and Grill that night. They didn't try to get any surveillance video from the bar or the surrounding areas. And that the eyewitness, the only person they actually talked to, places Josh at that restaurant at 2 a.m. when the fire started. And you'll also hear that the police didn't pull Josh's phone records. Records that, as you'll hear from Professor Pennington, show that Josh was not at Miss Eigenbrot's home at 2 a.m. Now, members of the jury, the events of this case are tragic. Tamara Eigenbrock should be here today, and no mother deserves to lose a child in that way. But you also have a very important job, and for you to do that job, you have to look past that emotion, and you have to look to the facts of this case. You must look for the blanks that the prosecution will be unable to fill, no matter how hard they try. And you have to look to the evidence, weigh the testimony, and make the decisions. That is all Josh Wallace asks of you. At the end of today, the evidence and testimony will show that Josh was not at Miss Eganbrott's home at 2 a.m. when the fire started. And we are confident that when you have a chance to review all of the evidence and testimony, you will reach the same conclusion and find Josh Wallace not guilty.
State, you may call your first witness.
This is the time the state calls Megan Eigenbrock. May I proceed, Your Honor?
Yes.
Would you please introduce yourself to ladies and gentlemen of the jury?
Hi, my name is Megan Eigenbrock.
And Megan, would you mind if I called you Megan for the rest of this proceeding?
That's fine.
Megan, you know I'm going to have to ask you some tough questions today. Some of them you might not be super willing to talk about, right? What was your daughter's name?
Tammy Eigenbrock.
And what happened to Tam?
On July 19, 2014, Tammy passed away.
How did Tammy pass away?
She was trapped inside of our house when it caught on fire, so she burned to death.
Where was your house?
We lived in a little single-family home on 918 Spring Street.
And what county would 918 Spring Street be in?
It was Queen County.
So before July 19th, July 20th, what type of relationships were you in?
Before July 19th, about a month before, I just gotten out of a pretty serious relationship with Josh Wallace. And in between that time and the time of Tammy's passing, I started seeing some guys. I went out for a couple of drinks, met people here and there, just trying to keep my mind off the breakup.
You spoke about Josh Wallace. Do you see Josh Wallace here in the courtroom today?
I do.
Would you point Josh Wallace out by an article of clothing?
He's the man at the end of the seats wearing the blue and white striped shirt.
Your Honor, would the record reflect the witness has identified the defendant as Joshua Wallace?
The record will so reflect.
Thank you, Your Honor. What happened 3 weeks before this incident between you and Joshua Wallace, the defendant?
Josh and I broke up. Just wasn't working out. He was getting a little bit, he was changing. He was getting a little too controlling, a little too demanding.
And when you broke up with him, where was the defendant living?
Josh was living with me at the time. And I knew that was gonna be hard for him to find another place on his own, so I did everything I could to help him so that it would be an easy transition for him.
And moving forward, on July 19th, what type of contact did the defendant have with you?
It had been a month since we'd broken up, and he couldn't let it go. Just day after day reaching out to me. He was desperate to just get a hold of me. And it just finally, I guess, came to a head on July 19th.
What type of messages were you receiving from the defendant on that day?
I was receiving scary messages. I mean, Josh tried to bug me a lot, but on July 19th, he took it to a new level. He threatened me, threatened himself. So I was scared for him, I was scared for myself, I was scared for my child.
On July 19th, what, if anything, did the defendant ask you to do?
Josh had left a few of his belongings at the house, and he asked me to collect them up and put them in a box and leave them out on the porch because he knew I refused to see him in person.
When did the defendant collect these items?
He came by that same day at about maybe 8 o'clock, and he picked them up and also said hi to his dog that lived outside in the backyard.
How do you know he came around 8?
I heard him out there talking with the dog, and the box was gone later that day when I checked, so I knew he had come by.
What was the last message that you received from the defendant on the night of July 19th?
I thought it was good. He came, he picked up his stuff, got to see his dog. I mean, it seemed like everything was fine, and then just before I went to bed, he sent me a text message saying that he wished God would take him off of this earth.
Megan, would you recognize layout of the former house that you lived in?
Of course.
Your Honor, I'm showing opposing counsel what has been previously marked as Exhibit 19. May I approach, Your Honor?
Yes.
Thank you. Showing the witness Exhibit 19. What is this document that I just handed you?
This is the floor plan of our house, 918 Spring Street.
And how do you recognize that that's your house? That's it.
Well, it's got the address at the top, and I recognize the floor plan as being my home.
Is it a fair and accurate depiction of the floor plan?
Yes, it is.
At this time, Your Honor, the state would move Exhibit 19 into evidence.
Any objection?
No objections, Your Honor.
Okay, without objection, state's exhibit 19 will be entered into evidence.
May I approach the Richard, Your Honor?
Yes.
And at this time, we would like to present a demonstrative of the same exhibit, just a blown-up copy.
Sure.
Thank you.
Your Honor, permission to reposition?
Yes.
Megan, is this just a blown-up copy of the document that I just shown you?
Yes, it is.
Now, prior to you breaking up with the defendant, what room did you sleep in?
Well, when Josh lived with me, we needed a little bit more space, so we took the larger bedroom. I think it's bedroom number 1 on there. That's where Josh and I slept together every night.
Okay. After the breakup, what, if anything, did you do to the arrangement of your house?
Well, after the breakup, I couldn't bear to spend another night in that room thinking about him, so I moved all my stuff out and I moved to bedroom number 3 because Tammy was already in bedroom number 2.
Okay. On July 19th, which room were you sleeping in?
I was sleeping in bedroom number 3.
What time did you go to bed?
I went to bed at about 9:30ish.
And when did you wake up?
Woke up in the middle of the night to a loud crash, and I guess it was about 2 o'clock when that all happened. I wasn't really focused or paying attention to the time.
You just testified about a loud crash. What was this noise?
Well, when I heard it, I thought maybe it was a rock or something. It sounded like the window had shattered, and I didn't know what caused the window to shatter. When I got up and I went to the window, I quickly realized what it was.
You just testified about a window shattering. Which window in particular was it on this diagram?
It was in bedroom number 1, the window at the bottom.
Your Honor, may I have the witness step down to better
Sure.
point the jury to which window?
all I saw was a flash of fire come into the room. Somebody had thrown, it was like a Coke bottle, and there was flames coming out of it, and I just saw it land in the middle of the floor and explode into a much larger fire.
After you saw this fire, what did you do?
Well, like I said, Megan's in bedroom number 2, so I just quickly shifted gears into getting her out and started pounding on her door. But as I was doing this, I could hear and see out of the corner of my eye more flashes of fire coming through the window and the sound of crashing bottles just constantly.
Thank you, Megan. You can take your seat back in the witness stand. After trying to get Tammy out of bedroom number 2 and seeing all those fire bombs, what did you do?
Well, the smoke was getting, there's too much smoke for me to even yell her name anymore. So I grabbed my cell phone and I ran outside to the front of the house, and that's where I finally called 911 to come and help Tammy get her out.
How soon after did help arrive?
Well, there happened to be a police officer right on the street, so they were there almost immediately. And they tried to get Tammy out, but there's no hope.
July 19th, July 10th, 20th. What happened to Tammy?
Tammy was never rescued. She was never taken out of that bedroom. The fire grew and grew, and it took over the whole entire house, including Tammy and her bedroom.
Megan, who was the last person to threaten you?
The last person that threatened me was Josh.
Who's the last person that you had an argument with?
Just before the fire, I had an argument with Josh.
And who were you scared of on the night of July 20th when you ran out of your house?
On the night of July 19th, I was terrified of Josh.
Thank you, Your Honor. We have no further questions at this time.
Your Honor, we actually asked that the prosecution leave the demonstrative up.
Okay.
And we'd like to preserve that, Your Honor.
Okay.
Ms. Eichenbrot, I know this might be very hard for you, but I have a few questions about what happened. You mentioned that Josh sent you some text messages that day, correct?
July 19th, yeah, he sent me a lot of text messages.
But you responded to some of those text messages.
When he asked me about getting his things, I responded to those.
And you answered some of his phone calls?
Yes, he was calling to ask about specifics of what he needed, and he was trying to explain to me where they were, so yeah, I answered his phone calls.
And none of those messages or phone calls directly threatened violence to you.
I mean, if I didn't do what he asked me to do, I'm sure he probably would have threatened me, so I just kind of complied with his request.
But he did not send you any directly threatening text messages or phone calls at that time.
At that time, not yet.
And so you allowed Josh to come by the house that day?
I wouldn't say I allowed it. I was tolerant of it for the purposes of getting all of his belongings out of my house once and for all. I thought this would be a way for him to stop contacting me, to be done with me.
And he didn't try to hurt you at all while he was at your house that day, did he?
He didn't have an opportunity to try. I mean, I kept myself inside that house. I wasn't going to give him a chance to even touch me.
But he didn't bang on the door?
Not that I heard.
Or shout your name?
No, not that time.
Or shout any threats at all?
Not at that time, no.
And at this time, he was playing with his dog, Sam, correct?
He was out back talking with his dog, Sam. He did that sometimes.
And Sam stays in your backyard in your house?
Yes.
So on this demonstrative you referenced earlier, a floor plan of your house, this is about where Sam is, correct?
That's correct.
And so you said that the fire started over here?
Your Honor, may I reposition?
Yes.
Thank you.
You said that the fire started over here at this bottom window, correct?
Well, the fire started inside the house. The bottles were getting thrown through that window, and then they crashed inside the house, so yes.
And Sam is really close to all the fire that was happening at that time, correct?
The line that draws Sam is actually his leash. He's got a pretty big radius that he's allowed to roam on. We actually tried to help Sam. We tried to disconnect him. He was as far away to the right of the house as possible based on his leash, and we just couldn't get it off in time, but yes.
And so you're saying Josh couldn't have got, or Sam could not have gotten off of his leash on his own?
No, he couldn't.
So someone would have had to untie Sam for him to get off?
Yes.
And Sam died in this fire, didn't he?
No, Sam didn't die. Sam's fine.
Sam was injured by the flames, though, when the police were trying to untie him,
No, he was fine.
but he was very close to the flames, correct?
Yeah, but like I said, his leash is really long. Sam was fine throughout the fire. He was a little bit scared, like I was, because I was screaming and he wants to protect me and he wants to protect Tammy. And he couldn't, but he was perfectly fine.
So you said you woke up around 2 a.m.,
I think that's about the time, yes.
and then you tried to get Tammy out, correct?
I pounded on Tammy's door to try to get her out of her bedroom in time.
And then you left the house to call 911 at around 2:07?
Again, I don't know exactly what time all this happened. It happened so fast. I did go outside and call 911, but I don't know exactly what time that was, and I know the police that I called weren't the actual police that were right there because I waved somebody down after I made the phone call.
So you called 911 sometime after 2 a.m.?
Yes.
All right, now, when you heard the crash, you didn't see anyone throw anything, did you?
I couldn't see anything. The bright lights of the fire just completely blinded me, and everything around it went absolutely dark.
But you didn't see Josh throw anything through the window, did you?
I couldn't see anyone. I couldn't see anything except for the fire.
And you didn't see Josh holding a firebomb?
I didn't see anyone. I couldn't see anything.
And you didn't hear him outside, did you?
I did hear him outside at one point, yes.
You're testifying that you heard Josh outside your house around 2 a.m. on July 19th?
I heard Josh outside my house earlier playing with his dog, yes.
Around 8 p.m.
Yes.
So you did not hear Josh outside your house around 2 a.m. on July 19th?
No, I couldn't hear anything but the fire.
And so you didn't see anyone. So you never saw Josh outside of your house at 2 a.m. on July 19th?
Objection, Your Honor, asked and answered.
Overruled.
Like I said, I couldn't see anything but the fire bombs that were coming through the window. That was all I could see. I wish I could have seen who was throwing those, but in my heart of hearts, I know who it was, and that's why I'm here.
All right, thank you. No further questions at this time, Your Honor.
All right. Anything further from the state on this witness?
Yes, Your Honor. What were you able to see in bedroom ruling on the night of the fire?
All I could see were these glass bottles with fire coming out of them being thrown as they crashed on the floor and exploded into a huge fireball. That's all I saw. That's all I could see. And with that much light coming from the fire, just everything around it just went dark. You couldn't see anywhere. I couldn't see out the window.
I have no further questions.
All right.
Thank you, Megan.
Witness may step down. Does the state have any further witnesses it wishes to call?
Yes, Your Honor. The state now calls Detective Matthew Dillinger to the stand.
Okay.
May I proceed?
Yes.
Please introduce yourself to the members of the jury.
My name is Detective Matthew Dillon.
And Detective, what do you do for a living?
I'm a detective with the Queen City Police Department. Work in the major crimes units. Major crimes unit. Excuse me, kind of hard to say. Anyways, we investigate violent crimes, homicides, things of that nature.
And how long have you been with that department?
16 years, good while.
Now, Detective, you said that you're currently assigned to the Major Crimes Unit. How do you go about investigating those crimes?
Oh, well, when a crime has occurred, you just go out to the scene, investigate and collect evidence, and try to find a suspect, question suspects, things of that nature.
And what are you looking for once you identify a suspect?
Oh, well, we're looking for a number of things. We're looking for evidence at the scene that connects to that suspect. We're looking at their reactions, where they've been, things of that nature.
And after you've completed your investigations, what happens?
Well, once we feel like we've gotten sufficient evidence, we contact the attorneys, we'll arrest them, make an arrest, and we end up in trial.
Now, Detective, I want to turn your attention to why you're here today. When did you first become involved with this case?
Well, I guess it was in the early morning of July 20th. I remember getting a call about a camera being trapped in the house. I responded to the scene. When I got there, I saw that there were already several firefighters and police units on the scene. And so I began patrolling the area, thinking that the suspect might still be near the crime scene.
Now, at that point, how were you able to identify a suspect?
Well, I found Joshua Wallace not very far from the scene, where Josh is Megan's ex-boyfriend, and so I asked him what he was doing, where he was going, things like that, and just conducted my investigation from there.
Now, you said you located Mr. Wallace not too far from the Eigenbrot home. Are there any roads or landmarks that you could tell us where in relation to her home he was?
Yeah, I picked him up on Dale Earnhardt Boulevard, which is actually just right around the corner from Miss Eigenbrot's house, the house that was burned down. He was about 100 yards from a path I found that led directly to Miss Eigenbrot's backyard.
Your Honor, I'm now approaching opposing counsel with what has been previously marked as Prosecution Exhibit 17. Permission to approach the
Yes.
witness? Detective, can you tell the members of the jury, what did I just hand you?
This is a map of the area that I was patrolling that night. You can see the address, 918 Spring Street, and you can also see the location on Dale Earnhardt Boulevard where I picked up Josh that night.
And is that a fair and accurate copy of that map?
Yep, appears to be fair and accurate.
Has it been altered or changed in any way?
Not that I can tell.
Your Honor, at this time, the prosecution would move to enter Prosecution Exhibit 17, the map of the area around the Eigenbrot home, into evidence.
Any objection?
Yes, Your Honor, I object to the foundation. We don't know who made that map, where that map comes from. There are stars on that map that have writing underneath it. We object to the hearsay of that as well.
Your response?
Yes, Your Honor. The detective just testified that this was a map that he used during his investigation that shows an area right around the Eigenbrot home. The sufficient foundation has been laid for this to come into evidence under this witness.
I'm going to overrule that objection. You can certainly cross-examine on the knowledge of the map.
And at this time, the prosecution would move to enter Prosecution 17 into evidence.
Yes, it is entered.
Now, and Your Honor, I'd ask for permission to publish a demonstrative of that map to the members of the jury,
Yes,
and permission for the witness to step down in use of that demonstrative.
certainly.
Permission to reposition.
Yes.
Now, Detective, you were just referring to different landmarks on this map. Can you show us on this map, where did you locate Joshua Wallace?
Absolutely. So you can see this is Dale Earnhardt Boulevard right here, and this yellow star indicates where I located Joshua Wallace that night, less than an hour after the 911 call went out.
And where on this map is the Eigenbrot home?
You can see the Eigenbrot home is indicated by the red star, 918 Spring Street. There's a path that leads from the backyard through this wooded area right here and comes out right at the intersection. I located Josh, 100 yards from that path.
And I also see a blue star on this map. Can you tell the members of the jury, what does that star represent?
That's the neighboring house to 918 Spring Street, 915 Spring Street. through the course of my investigation, I learned that Josh lived in that house before moving in with Miss Eigenbrot and Cameron Eigenbrot.
Thank you, Detective. You may retake the stand. Now, Detective, you just talked about that path that goes through the woods. Did you investigate that path during your investigation?
I did. I walked that path. It was kind of hidden in a lot of briars, so I had to move into the neighboring yard to get through those briars and go on to that path. But I was eventually able to walk the path, and that's how I realized where it came out. I walked it all the way to Dale Earnhardt Boulevard, and then I was like, oh, this is where I picked up Josh.
And what, if anything, did you find while investigating that path?
Well, I found several things along the path. As I mentioned, the briars were at the entrance and all through the path. And that's important because when I picked up Mr. Wallace that night, his clothes were ripped and he had multiple scratches on his arms and legs. So I suspected that this could be where those scratches came from, the briars on the path. I also noticed several green Coke bottles and other glass bottles along the path. And that's significant because I suspected that these bottles could have been some of the bottles used to make the Molotov cocktails that were thrown at Miss Eigenbrot's house.
You said that you found those glass bottles along the pathway. At any other point during your investigation, did you find glass bottles like those?
Well, I found glass in the house when I first went into the house the morning of July 20th. There were glass shards, but I could not collect that as evidence because as I found them, my fire reared back up in the home and we had to evacuate immediately. When I went back in, they were gone. So.
Now, you said you located Joshua Wallace on Dale Earnhardt Boulevard around 2:40 in the morning. How did he appear at that point?
Well, he had a very dirty look to him. He smelled very strongly of gasoline. As I mentioned before, his clothes were ripped and muddy and dirty. He had a backpack on.
Did you determine what was inside of that backpack?
I did. I searched the backpack. Found a Steel Reserve beer can was probably the most significant thing I found. That was significant to tie him back to the scene because I found lots of empty Steel Reserve beer cans in Miss Eigenbrot's backyard. The same Steel Reserve beer that I found in Mr. Wallace's backpack. I also found a lighter and found a flashlight and a cell phone.
Now, Detective, you talked about glass inside of the Eigenbrot home. What did that tell you, if anything, about the weapon used to start this fire?
Well, I suspected, because of the glass and just the nature of the fire, this was a Molotov cocktail thrown. We see these pretty commonly in my field. They're often thrown at police during riots or in the commission of crimes, things of that nature.
How are these weapons made?
You take a glass bottle and you fill it with an accelerant, commonly gasoline, or it can be other accelerants, just easily accessible accelerants. And you can take a piece of fabric or something that acts as a wick, so then when you're holding the bottle and you light the fabric, it burns, but it doesn't explode until you throw the bottle and the glass shatters, and that's when you get a large fire explosion. It's like a fire bomb. Some people call it a poor man's hand grenade. Like I said, they're pretty common in our field, is what we see.
And what, if any, evidence of an accelerant like you just talked about did you find at the scene of the crime?
Well, we found an empty gas canister under the neighboring house. That empty gas canister had fresh knuckle marks on it, and it was empty. It had a strong smell of gasoline, more so than you would find just from your average gas canister. There's a strong smell of gasoline around it, as if somebody had spilled some gas around there. And so I suspected that this could have been the gas.
Objection, speculation.
Any response?
Your Honor, at this point, the detective is testifying about the steps he took in his investigation, specifically the role that this gasoline played in the weapon that he just testified caused the fire at the home. This is based on his perceptions, what he observed in his training in law enforcement.
I'm speculating to the condition of the gas can, whether it was full or empty before this is just that, a speculation. He has no way of knowing there's no foundation that's been laid for him to assert any type of actual knowledge of that fact.
I'm gonna overrule that at this time, and you can proceed.
Yes, Your Honor.
It was an empty gas canister, so I thought that maybe this gas canister could have been the one used to fill up Molotov cocktails that were thrown. I mean, it was right beside the house. So.
Now, you said you located that in a crawl space. Who lived in the home that you located that gas can at?
That's the home that Josh lived in before he moved in with Tammy, right next door. He was familiar with the home. He used to live there, used to have access to it, and no one was living there at the time, so it was empty.
Now, Detective, you said that you located Josh Wallace on the morning of July 20th. At any point, did he make a statement to you about your investigation?
He did. That morning we went to the station, and he made a statement. He adamantly denied knowing anything about the fire, but as I questioned him about the fire, he made some statements that made me suspect him even more.
What were those statements?
Well, I began to question him about the fire, and just kind of asking him several questions. I asked him if he had any military experience. He immediately responded that he didn't know anything about making bombs. At that point, there had been no mention of a firebomb or a Molotov cocktail or anything that he would have known to indicate him to give that response. Yet he felt the need to give that response, and those inconsistencies are what raised red flags in my mind.
And what, if any, information could the defendant provide you about his whereabouts on the morning of July 20th?
He cannot provide me any proof of where he was that morning, July 20th. He said he was at a bar drinking, but could provide no evidence to corroborate that.
You said he could provide no evidence to corroborate that. What did he tell you about how he arrived at that bar?
He told me that he walked to the bar and walked home from the bar. He says that he was there with a man named Robert. He could not give me Robert's last name. Again, could not give me a receipt. Could not tell me where to find Robert. He told me that he walked to and from the bar when I first picked him up. Later on in my investigation, several days later, we arrested Josh Wallace for this crime, and I questioned him again. At that time, he gave me an inconsistent statement saying that he had gotten a ride part of the way to the bar, part of the way from the bar.
Could he provide you with any evidence of the names of the individuals that gave him that ride?
He could not tell me the names, and he, again, this is an inconsistent statement to the one that he had just given me. And again, these are more red flags that we're trained to recognize as law enforcement officers. And it again affirmed the reason why I effectuated that arrest warrant.
You just mentioned an arrest warrant. After July 20th, when was the next time you had contact with Josh Wallace?
Yeah, we executed a search warrant on Josh Wallace's home. There we found clothes that had been washed. We were hoping to get some evidence off those clothes, but again, like I said, they had been washed, and so we weren't able to retrieve any evidence from those clothes. Found 2 cell phones. The battery had been taken out of them. When we first got to the home and executed the search warrant, Josh was not very compliant. We had to remove him from the
Objection,
home.
Your Honor, narrative.
Overruled.
We had to remove him from the home in order to continue our search.
Now, other than the clothes you just mentioned, what else, if anything, was found during that search warrant?
We found a lighter. We found shoes. We sent all that off for testing.
Now, Detective, at any point during your investigation, did you question the defendant about his relationship with Megan Eigenbrod?
Yeah, he told me that Megan was his girlfriend.
Now, Detective, on July 20th, did you actually go to the Eigenbrod home?
I did. Yeah, after questioning Josh that morning, I went to the home.
Can you explain to the members of the jury, how did that home appear when you arrived?
I mean, you can just imagine a home that has been burnt so severely that someone died in the fire. It was an awful sight. We can see where the fire started. It's very clear that it started in the back bedroom. Again, I told you about the shards of glass that found and everything like that.
What, if anything, did you do to document the scene?
We did take pictures of the home to document the scene.
Will you recognize those pictures if I showed them to you here today?
Sure.
Your Honor, I'm now approaching opposing counsel with what has been previously marked as prosecution exhibit 21.
Okay.
May I approach the witness?
You may.
Detective, can you tell the members of the jury what I just handed you?
This looks like a picture of the house shortly after the fire. This is the house, and you can see smoke coming out. It looks like it's still on fire a little bit.
Now, has that photo been changed or altered in any way?
No, this is how it looked that night.
And it fairly and accurately depicts on how that home looked?
Yeah.
Your Honor, at this time, the prosecution would move to enter prosecution exhibit 21 into evidence.
Any objection to Exhibit 21?
No, Your Honor.
Without objection, State's Exhibit 21 will be entered into evidence.
Your Honor, at this time, we'd request permission to publish exhibit 21 to the members of the jury in the form of a demonstrative aid,
Yes,
and permission for the witness to step down and make use of this demonstrative.
the witness may.
Permission to make position.
Yes.
Detective, can you tell us what we're looking at here?
You can see where the fire started. You can see significant charge right here, where it looks like this is the back bedroom where the Molotov cocktail was thrown into the window.
And based on the damage to the home, what does this tell you about the weapon that was used?
Objection, Your Honor. I feel like this would call for an expert opinion. An expert testimony as to, based on this damage.
The question was, what type of what was used?
What type of weapon was
Weapon.
used?
Overruled
Excuse me.
as to that question.
Yes, Your Honor. Now, again, Detective, based on the damage that you just described, what does that tell you about the weapon that was used?
As you can see with these two windows missing, it indicates that something was likely thrown into the window. That's what we think was the fire bomb thrown into the window.
All right, you may retake the stand, Detective. Now, you've spoken at length about the Eigenbrot home. Where inside that home was Tammy Eigenbrot found?
We found her in her bed, or her remains in her bed. She died as a result of the fire.
Your Honor, I'm now approaching opposing counsel with what has been marked as prosecution exhibit 16. I approach the witness.
Yes.
Detective, tell the members of the jury what I just handed you.
This looks like a picture of Tamara's bedroom after the fire.
And when was that photo taken?
Again, the morning after the fire.
And does that photo clearly and accurately, or fairly and accurately represent what that room looked like at that period of time?
It's brutal.
Has it been changed or altered in any way? Your Honor, we now move to enter prosecution exhibit 16 into evidence.
Any objection?
Yes, Your Honor. Same objection as before. 403 states that this image, as the detective just said, is a brutal image of Tamara's body. This is unfairly prejudicial, and it is, the probative value is vastly outweighed by the prejudicial value that this picture, that the gruesomeness of this picture reflects.
Response?
Yes, Your Honor. At this point, the court has already addressed this evidentiary argument. We heard it in pretrial, and the court overruled defense counsel's objection. And raising it again at this point, the court, in all fairness, cannot go back on the ruling that it already provided to the state.
The court can, if it wants to. I mean, it's the same objection to the same piece of evidence. I'm going to overrule it. If this is the only photograph of it, then that's fine. If they decide to produce more photographs of the bedroom or of the body, then we can go there at that time.
For preservation purposes, may the record reflect that the defense
Yes.
objected to this
You have
picture.
objected.
Thank you.
Objection is overruled. Exhibit 15, 16 is admitted into evidence.
And we'd ask for permission to publish Exhibit 16 to the members of the jury in the form of a demonstrative.
Yes.
Now, Detective Dillinger,
You may.
you can stay on the stand this time. Just tell us, what are we seeing in this picture?
Well, again, you can see how the fire was so brutal that there's hardly anything left on the mattress. That is where we found Tamara's body, and that is her body there on the mattress.
Based on your investigation, what was the cause of Tammy's what was the cause of Tammy's death?
This is where Tammy burned to death, right here in this picture. That's where she was, and she burned to death.
All right, thank you. No further questions.
All right, any cross-examination?
Yes, Your Honor.
And Your Honor, I at this time asked to approach and retrieve the exhibits that were entered and publish them to members of the jury.
Yes.
Detective, the fire was reported at 2 a.m., correct?
I believe that's when I got the call.
Josh Wallace was at the Three Monkeys with Robert Saunders until 2 a.m., correct?
No, I don't think he was.
But the house was over a mile away from the Three Monkeys, correct?
I don't know the distances.
You found Josh Wallace walking home, didn't you?
I did, shortly after the fire.
And when you stopped him, you told him that you were investigating a fire.
I did.
You pulled up next to him and he let you search for his wallet.
He was hesitant, but eventually I retrieved the wallet. Didn't want him reached into any of his pockets. Don't know what else he had in there.
Never gave you any trouble?
Well, I don't know that I'd say that, but eventually, yeah, he did comply.
He consented to you searching him.
I mean, there's always trouble around guys like Mr. Wallace, but, he eventually knows how it works.
When you searched him, he only had a few things on him, didn't he?
Significant things, yes.
But nothing that would be a component of a Molotov cocktail, was it?
He had the lighter, which I suspect is the heart of the weapon that he used to light that Molotov cocktail.
And cigarettes, correct?
He did have cigarettes on him. You won't find guys like Josh Wallace without cigarettes very often.
You noted his outfit was dirty that night, right?
Very dirty.
But you never asked him how he got that way.
I suspect it is from the trail that I discovered, which is where he was coming out of when I picked him up that night.
Detective, do you know what Josh does for a living?
I understand he works for a lawn maintenance business.
He's a landscaper.
Yeah, that's what I understand.
And you said he smelled like gas, right?
2:45 in the morning.
But you only noticed this when you came up close to him, right?
The presence of gasoline was very strong, man.
Being a lawman, he uses lawnmowers, doesn't he?
When we arrested him, he was actually on lawnmower. Yes, ma'am.
Okay. But you never asked him if he had changed clothes from work that day, did you?
Again, I would imagine that a smell this strong cannot be present that long after he had been off work.
So then you asked him to go to the station with you, right?
We did. We went down to the station and asked him questions.
He went willingly.
Again, he was very hesitant, but like I said, Josh Wallace knows how these things work.
He even stayed for 2 hours,
He did. He stayed about 2 hours.
even though he told you he had to go to work again that day.
I think he did leave from there to go to work. Yep,
And after that, you went to the scene of the accident.
I did. I returned to the house. I went there several times, but after the initial call, that was my first time going back to go inside the house.
And
They had the fire in it.
later, you searched the house next door, correct?
I did. Talked to the owner. He let us in to look around. Again, that's where Josh Wallace lived before he moved in with Megan.
And in the crawl space, you found a gas can.
I did. And we suspect that that's the gas can used to fill Molotov cocktails thrown that night.
You tested that for DNA, didn't you?
we did send off a DNA test. They were not able to get any DNA test results from it, unfortunately.
So you didn't find any of Josh's DNA on that gas can?
No, the test did not come back with his DNA.
While you were there, you took pictures, didn't you?
Took pictures of the house, yeah, took
You
pictures of the bedroom, we saw all this.
And you took pictures of beer cans,
I did, the same Steel Reserve beer cans that we found in Josh's backpack.
and you took pictures of glass bottles.
I did with bottles on the trail, yes ma'am.
But those pictures aren't here today, are they?
No, they're not, but you don't need them, you have me to talk about them.
You didn't bring any of the pictures of the cans.
Telling you about the cans right now.
You didn't bring the pictures of the bottles.
Nope.
Let's talk about what else you learned. You also learned from two people. Tamara's father was Chad, right?
I'm aware of who Chad is.
And you found out that Chad was violent.
I don't know Chad to be violent. I know, I was told he was violent, but again,
So you were told that Chad was violent.
Objection, this is hearsay.
Your response?
Yes, this is not being offered for the truth of the matter, so that this is only being offered to show the mental state of the detective in the course of his investigation.
Overruled.
You found that Chad was in debt, child support.
Josh Wallace told me that. I don't know that it's true.
And he had recently been ordered to pay back that child support.
Objection, relevance.
Your
What is
Honor, this goes to show that the detective did not do the detective made a shoddy investigation. He had other people who had motives, had violent history, who could have and may have hurt Tamara and Megan that were not my client, Josh Wallace.
Anything else?
Your Honor, just that at this point, defense counsel has not offered any evidence other than this outstanding child support payment to show a motive or an opportunity of this person named Chad, who's not even here today, that why he want to harm Ms. Eigenbrod. At this point, the fact that he had an outstanding debt to Ms. Eigenbrod makes no fact of consequence more or less likely, and therefore this is irrelevant.
My next question will actually show that he has a history of wanting to harm Ms. Eigenbrod.
I'm going to overrule it for purposes of the investigation, but anything beyond that, it's going to be restricted. So, information related to his investigation only.
Yes. In the course of your investigation, you found that Chad had a history of beating Ms. Eigenbrod, didn't
Again,
he?
I don't know that to be true. I know that's what Josh Wallace says. It's a convenient explanation.
But you never went to family court? Never went and searched any of the child support files?
I believe he's lying, so I don't need to.
Never questioned Ms. Eigenbrod about Chad?
Nope.
Or any past abuse?
Nope,
Never even attempted to speak to Chad, did you?
didn't need to.
You didn't do anything to investigate Chad at all.
Chad's not a suspect. Josh Wallace was.
I'd like to talk to you about some more things that you didn't do. You didn't follow up with the Three Monkeys to check out Josh's story.
I'm familiar with Three Monkeys.
You didn't go speak to the bartender.
They don't talk to police officers very often.
That's, yes or no? You did not go and speak to the bartender.
I know the bartenders. I've responded to many calls at the Three Monkeys, and I know that the bartenders at the Three Monkeys don't like police officers very much.
So that's a no.
Again, no, because they
Okay.
don't talk to me anyway.
You didn't go speak to anyone else there, did you?
Like the bartenders, most of the patrons don't have any interest in talking to police officers either.
Detective, that's a no?
Nope.
Okay. You didn't check any of the security footage from inside the bar?
The Three Monkeys doesn't have security footage.
So you wouldn't check to see if they had security footage?
I'm familiar with the Three Monkeys, and I know that they all have security cameras.
You didn't even try to find footage from around the surrounding area, did you?
Nope.
You didn't follow up on any of that information, did you?
No, I didn't need to.
Detective, you have no eyewitnesses that placed Josh at the scene, do you? You're telling me, is your,
Megan Eigenbrot believes that Josh Wallace is the one who threw that Molotov cocktail, and I think she's right.
so it is your, Megan told you that Josh was, that she saw Josh, is that what you're saying?
She never said that she saw him.
Thank you. You have no fingerprints,
Just because there aren't fingerprints doesn't mean he's not the one who did it.
you have none of Josh's DNA, do you?
We did take a DNA swab from Josh, yes.
You have no DNA that links Josh to the scene, do you?
We just took a DNA sample from him.
But you have no DNA that links Josh to that scene, do you? That is a no, correct?
No.
Okay. And the only eyewitness that you have places Josh Wallace miles away at the Three Monkeys at 2 a.m., correct?
I'm sorry?
The only eyewitness that you do have, Mr. Saunders, places Josh at the Three Monkeys miles away at 2 a.m., right?
About Robert Saunders?
Yes.
He came and talked to me 3 months after we had arrested Josh Wallace. I'm not gonna believe him. You kidding me?
So that's a no. I mean, that's a yes. The only witness that you have places,
I do
Places
not
Josh
consider
in the
Robert
crib.
Saunders an eyewitness.
no further questions.
Any redirect?
Yes, Your Honor. Detective, the defense counsel just asked you about a man named Robert Saunders. When did you first make contact with him?
Robert Saunders is a drinking buddy of Mr. Wallace and came forward 3 months after we had completed our investigation and conveniently said that he was with Josh that night and there's no way that he started that fire and we should just let him go.
What sort of information did Mr. Saunders provide you on the relationship between the defendant and himself?
Well, he came in and anytime somebody comes in with information about a case, we have to take their statement. So I being the lead investigator, I took a statement and we talked about how they knew each other from high school.
Your Honor, this is hearsay. What they talked about, what Mr. Saunders said, and if this line of testimony goes on, it will lead to hearsay and information gained from hearsay.
Your response?
Yes, Your Honor. At this point on cross-examination, defense counsel went into this conversation and elicited certain substantive material parts that are favorable to their case. In all fairness, it's only fair for us to be able to explore these statements and question the defendant about these statements in their entirety.
Anything else?
I do not believe that we opened the door for, we did not open the door for the exact statements of Robert Saunders. If they have something about what Robert Saunders says, they can cross-examine him when the defense puts him on the stand later today. He is here, and if they would like to cross-examine him, they can then. However, hearing what he said from the detective is blatant hearsay, Your Honor.
I think you asked him a lot of questions about what Robert Saunders told him and who was with Robert Saunders and went into his alibi from what I could tell on your cross-exam. So I'm going to give him a little bit of leeway to kind of inquire as to what investigation he did on Robert Saunders and what that revealed. So it's overruled.
Detective, what was significant about Mr. Saunders' statements to you?
Sure. He said he was at the Three Monkeys with him and everything, and it was just, being his relationship to Josh and how long after our investigation was completed he came forward. I just, it was just, it's not normal, and I didn't believe it.
Now, other than that information, excuse me, Detective, what, if any, contact information did Mr. Saunders give you during that interview?
Well, I had to fill out a witness form, name, address, telephone number, all the basic contact information, and then asked him to handwrite his statement after we, talked and everything. And he wrote that statement, and I submitted it as part of my report in this case.
Do you remember what Robert Saunders' phone number was?
Off the top of my head, no, but it's on his witness statement.
Your Honor, permission to approach the witness
Yes.
or to first approach opposing counsel? May I approach the witness?
Yes.
Tell the members of the jury what I just handed you, Detective.
This looks like Robert Saunders' statement.
That's the statement we've been discussing at length today.
Yes, it is.
What is Robert Saunders' phone number?
His phone number is 704.
Objection on relevance to this entire, line of questioning?
Overruled.
704-555.
Objection, Your Honor, this is outside the scope of my cross.
Any response?
Your Honor, again, these are statements contained in the interview that defense counsel went into at length on her cross-examination. These are all from that same interview, and as the court previously ruled that in the interest of fairness, getting the rest of these statements out after the defense has already opened the door is allowed.
Anything on that?
No.
Did you actually go into the interview he had with him, or just what
I
he was
actually
told
didn't.
about Robert Saunders?
I didn't go through any of this, actually. The only questions that I asked that even related to Robert Saunders, he brought up that Robert Saunders told him that Chad was in debt on child support, and he was the one who brought that up. I did not elicit that part, and I also said, what?
I never said Robert Saunders is the one who told me.
You said Robert Saunders was one who told you something.
Well, I know you asked him about an alibi witness and an eyewitness that places him at the Three Monkeys Bar at 2 a.m.,
Yes, I
referring
did.
to Robert Saunders. So my question is, did you ask him any questions about the interview he had with Robert
No, I
Saunders?
did not.
Right, then I'm going to sustain that objection.
Detective, defense counsel asked you questions about an alibi witness that came forward. When did that interview take place?
3 months after I completed my investigation.
On what day did that interview take place?
Looks like October 25th, 2014.
What other information did you gain during that interview? Any contact information?
Again, Your Honor, just
Sustained.
Detective, who did you find on the morning of July 20th near the Eigenbrot home?
Joshua Wallace, the defendant.
Who did you find that smelled of gasoline on that morning?
Josh Wallace.
objection asked and answered.
Overruled.
I'm
Josh
sorry.
Wallace.
Who did you find whose clothes were muddy and ripped?
Josh Wallace.
Who is the only person that has been arrested in the death of Tammy Eigenbrot?
Josh Wallace, the defendant.
All right, thank you. No further questions, Your Honor.
Witness may step down. Does the state have any further witnesses?
No, Your Honor. At this time, the state rests.